I'm fine. That's fine. Good, I can go ready to go here.
That work for you?
I think so. I think we're fine. All right, just go ahead then. All right, well, good evening. Welcome to the City of North Miami Ethics briefing. And let me, first of all, thank you for coming. My name is Joe Santorino. I am the Executive Director of the Miami-Dade Commission on Ethics, which makes me real popular in all the cities of Miami-Dade. I have had that position only since last September, but prior to that I was the Chief of Public Corruption in the Miami-Dade State Attorney's Office for probably 15 years or so, and I made a lot of friends in that position too. I want to tell you that I've spent my life, almost all my life in public service, not all of it, but almost all of my career at least. I have come to conclude that there is no more important subject in government than ethics, because ethics is really the threshold. If a government lacks ethics or there has an appearance of a lack of ethics, it undermines everything they're trying to accomplish. So we have to start with ethics. My outreach coordinator is here with me, Robert Thompson, and he and I will be covering a lot of ground here tonight. I will be happy to answer questions from anybody that wants to ask a question about the law. We're here to talk about the law or the ethical requirements. So I'm not here to discuss anything else that's going on in the community. This isn't a political type of forum. We are here merely to discuss the ethical requirements under the county code, and as well as some of the state laws regarding transparency and sunshine. And I will answer questions if anybody has them. I'm going to try to cover as much of this ground as possible. Usually we end up having to shorten it in some way. If there are a lot of questions, we'll adjust it accordingly. But in any event, I want to thank the City of North Miami and for the invitation to come and do the presentation. We do this, one of the things we do in the Ethics Commission is we get around the county and we do these presentations with every municipality that wants it, or with the county government, various departments that want it. We do not only do ethics sessions, we do election law sessions. In fact, we were here, I think, about a year ago, or close to that. We did an election law session for candidates and people running for office. That really is the most positive part of the job of being involved in ethics. The education part of it, we also give opinions to people. A little bit more about that later. But then again, of course, if we don't get the message across, then we have an enforcement arm too, and we do enforce the code, and we also work with some of the law enforcement agencies, the police agencies, the state attorney's office, on investigations of misconduct. So what I'm going to start off with here is the Florida Sunshine Law and Public Records Law, which most people should be familiar with. But the thing about the Sunshine Law is that there are always little twists and turns in it, and nobody ever is a complete expert on it. And it's not a bad idea to go through that, and as well as talk about the Public Records Law, because they are really a vital part of the ethical construction of the state of Florida's laws and Constitution. It's a very strong policy in Florida regarding openness and transparency in government. So much so that the Florida Sunshine Law, I always say this, is a radical law. There is only one other state in the country that has as extensive a sunshine law as the state of Florida. That's the state of Colorado. And the point I make here is that the Florida Sunshine Law goes well beyond most of the open meeting laws in the country, which generally provide you have to have open meetings and notices and so forth, to the point that any discussion between two members of a public board is going to be considered a de facto meeting, which that the Sunshine Law applies to, meaning that two people on a board, not just the city council, but any public body really or board in the city, they can't talk to each other outside of the confines of a noticed and regularly held public meeting that's open to the public and so forth. So that's a radical idea. That does not happen in most places. So we start off with that premise, and I understand that it's kind of it's almost an anti-intuitive kind of thing, because everybody's natural instincts are to talk to people, to talk to the people that you're working with to discuss issues, and it's a severe restriction on that. And I have on occasion prosecuted Sunshine Law cases as a prosecutor. And sometimes people are stunned. Going, whoa, you mean that you actually enforce that law? Yes, it does get enforced. All right, I'm going to start this off, though, my presentation, and I only promise this is only going to be about a 5-minute history lesson here, but I'd like to give people a sense of the background of open government and where did this idea come from. You can go back to 1515, and Sir Thomas More, who wrote a book in which he outlined, a utopian government. It was called, I think, appropriately, Utopia, because this idea sometimes is called utopian under the Sunshine Law. And he came up with this idea of this perfect society, and one of the things he promoted in that was that there would be this common council, and nothing that relates to the public business could be discussed anywhere except within this public council, and it was a capital crime in Utopia to discuss something outside of this council. Now, it's not a capital crime in the state of Florida. Everybody can relax on that. It's at most a criminal misdemeanor, but still, it has serious consequences. We'll move ahead here to the founding fathers, and you've got James Madison, who often is referred to as the father of the U.S. Constitution, and who tells us that you can't have a democracy or a republican form of government without giving the people information. Otherwise, you end up with a farce or a tragedy. Okay, very important aspect of any type of constitutional republican form of government, that the public gets information about the government. Otherwise, it doesn't really function. But what did, for those of you who might be interested in constitutional history a little bit, what did the father of the Constitution put in the U.S. Constitution that would guarantee that everybody would have a right to get information from the government? Anybody? Liberty. Well, does that give you a right to get information? Somebody has a... Well, the petition means you can ask. You can ask for something, but does that give you a right to get it? All right. I'm sorry, but this is a trick question, because he didn't put anything in the Constitution to guarantee a right of access to information. All right. Some people say the First Amendment, freedom of the press. Yeah, you got freedom of the press. They have a right to spread the information around, but it doesn't necessarily give them the right to get it. So it's not really in the Constitution. If there are federal statutes, there's a Freedom of Information Act. A lot of you have heard of that. Gives you a right under the law to get information from your federal government. The Florida Constitution is different. The Florida Constitution has in it both the Sunshine Law and the Public Records Law. So that tells you in the state of Florida, it is a state constitutional right. The value of openness in government is greater in the state of Florida than in the federal government. Then we move into the early 19th century, and you've got the great Justice Louis Brandeis, who tells us that basically publicity or sunlight is a disinfectant. It is a policeman. It is something that can help inhibit or retard corruption, and it's something that's needed to keep government honest. It's not just to keep it functioning, but it's to basically enforce honesty in government. Of course, that was during the progressive era in the early part of the 20th century, when you had all all these muckrakers writing about corruption in the big cities and so forth. So we see that's the tenor that transparency has taken on over the years. All right. Now, State of Florida Constitution. I'm going to run through some of this fairly quickly because I'm not here to give a legal lecture, but to just kind of familiarize you with the law in this area. The Florida, as I said, there's a constitutional provision for public records. There is a constitutional provision for open meetings or for what we call the Sunshine Law. It's embedded in the State of Florida Constitution. And we have, as happens, we have a statute that the legislature promulgated to basically spell out in more detail the Sunshine Law, and it's 286.011. And here it is. And if you look at it, it doesn't really tell you that much. I mean, it doesn't read that differently from the open meeting laws in other states. You could read that law all day long, and you wouldn't have any idea that it is so restrictive that it applies to two people on any board being, in effect, a de facto board that has to operate under the Sunshine Law. And that is because there has been judicial interpretation over the years of the law, and it has expanded the meaning of the Sunshine Law. Okay, well, what are considered, first of all, the basic requirements of the Sunshine Law? Well, first of all, meetings have to be open to the public. You cannot, for instance, lock the door and not let people in. Believe it or not, that has happened in some municipality in Miami-Dade County, not this one, but it has happened. I won't mention names. I don't want to embarrass anybody, but they did in one municipality lock the door during a meeting. That was a Sunshine Law violation. You've got to have reasonable notice of your meetings. You've got to publish your meetings, and I'm sure you do. Is your clerk here? Your city clerk? Oh, yes, okay. What is your... What is the time that you generally use to give notice for a public meeting? 48 hours? All right. And that's probably about the minimum, but there is no specified period. When it says reasonable notice, it means reasonable notice. It's got to be something that the court would find to be reasonable. 10 minutes, obviously, wouldn't be reasonable. 2 hours wouldn't be reasonable. 48 hours is probably about the minimum. I don't know of any that would be less than that. And you've got to keep minutes of the meeting. There's got to be a record, a public record of what went on in the meeting, who was there, what was discussed, and so forth. That's because obviously not everybody can get to the meeting. And so people that want to know what happened at the meeting, well, they have a right to have minutes. These days, most city councils, I think, tape record their meetings. Do you do that here? So is there a tape recording of a meeting available if somebody wants to see it? So you're covered. Okay. And of course, we're trying to avoid this situation where we have non-existent meetings. That's the purpose of the Sunshine Law. Okay. Now, this is the language in a case which really is you see almost all the time in Sunshine Law cases. This is the language that's always repeated, at least in some fashion, to show you how the judicial interpretations have expanded the notion of the Sunshine Law. First of all, the statute's going to be construed to frustrate all evasive devices, meaning that if it looks like somebody's trying to get around the Sunshine Law, they're probably going to be found in violation. In other words, the spirit of the law really is what counts, and the spirit of the law is to have open debate and of all issues before the council or the commission, and not to try to come up with ways of evading or sneaking around the law. It includes the collective inquiry and discussion stages. It's not just the voting on matters, it's the entire discussion stage. So once the board starts to talk about it, even if they have preliminary discussions or hearings or whatever, all of that's got to be part of the Sunshine Law process. All of it has to be conducted in accordance with the Sunshine Law. And it relates not just to matters that might be on the agenda that you know you're going to be voting on. It relates to any matter on which foreseeable action will be taken. And if it's foreseeable that you're going to have to vote on the budget next year, well, you really shouldn't be talking about next year's budget, all right? I mean, that's the kind of thing it extends to that. It's not just, it's on the agenda for the next meeting or the meeting after that. It's foreseeable. If it's foreseeable that you're going to have to decide this issue in the future, well, then that's an issue that the Sunshine Law will cover and should not be discussed in private. All right, so let's talk about some of the special situations that we get into with the Sunshine Law. By far, as I said already, the most significant and radical thing that has been crafted onto the Sunshine Law by judicial interpretation is that it includes these informal discussions between two board members. If they're going to talk about something that's foreseeably coming before the board, bang, the Sunshine Law applies. They can't do it. Doesn't mean they can't talk to each other about something else, about the weather or about the Marlins or anything that doesn't connect to city business. Perfectly all right. Sometimes we get complaints, I saw Councilman so-and-so and Councilman so-and-so, they were meeting at the coffee shop. Aren't they committing a Sunshine Law violation? Well, no, not necessarily, unless somebody overheard them and can tell us what they said. Delegation to one member. If your board were to say to one of its members, look, we're giving you the authority to go out and do this on behalf of the board, in other words, as the board's representative. Now that person has been given some authority of the board, and that person, that one individual, may have to do whatever they're doing in the context of Sunshine Law meetings. They're not going to be able to have private meetings because let's suppose they're screening applicants for a position, for a city position, and they're going to be given that kind of delegation. They become subject to the Sunshine Law as if that one person was an entire board. Use of a liaison, okay? You cannot obviously accomplish through another person what you can't do yourself. So if two members of a board can't speak to each other, that means they can't use a third party to go talk to somebody on the board to relay a message or to get a message returned to them. Can't do that. Now, as a matter of course, people hear things. We know that. People hear things in the community. If you're a politician, you're going to be talking to people. You're going to be out there in the community, and you're going to hear, this commissioner said this, or this commissioner said that. Well, that's okay. I mean, that's information that's out there in the public forum. But you might talk to the media, and the media is going to report it, and then another member of your council is going to read it. That doesn't involve Sunshine Law violations. So what the Sunshine Law is geared to are two-way communications between two people on the board. In other words, one person's talking to another person and responding. So if it's a matter of talking to other people in the community, which you do almost all the time, that's not a problem. The Sunshine Law does not restrict you from talking to people in the community. It includes, of course, any kind of written or telephonic communications. You can't talk on the phone. You can't pass notes to each other in the middle of a meeting, which, by the way, if that were to happen and if it related to something in the public business, probably that becomes a public record instantly, and you'd have to show it to somebody. Okay, emails, text messages, Twitter, Facebook, blogs, and so forth. I'm really too old to do a lot of this stuff, but I understand that people do this. If I can do email, that's about as far as I'll go. This is a whole area. The technology is changing so quickly that the law hasn't caught up to it yet, and I don't know where we're headed here, but I can tell you that there have been a lot of problems created by the social media. Facebook, for instance, and I don't do Facebook, and I tell people don't do Facebook. It's just going to be trouble. But I understand if you're in politics, people tend to have Facebook pages and so forth. Be very careful with that. I mean, don't friend another member of your board. I mean, that's not a good idea, because then they get access to information, and if there's some information that gets into you're on your Facebook page regarding what you're doing on some public issue, that can look like a Sunshine Law violation. So, my general admonition is to be very careful. It's probably best that you avoid putting out, if you're going to have a Facebook page for your own friends and family and so forth, that's fine. But once you start getting involved in discussions of public issues in a Facebook page, be very careful. Even on email, because what can happen on email, and I've seen it happen, is you might send an email to somebody, not intending that it go to somebody else, and then that email gets sent to somebody else, and before you know it, there's a whole email trail, and all of your colleagues somehow or another get that email. Now, you didn't start out with the idea of communicating that, and I understand you probably wouldn't be guilty of a Sunshine Law violation, but it creates the appearance of a Sunshine Law violation, and somebody wants to make a complaint to the state attorney's office, say, hey, this was a conspiracy for them to all kind of communicate with each other through these other people. Boom, now you got an investigation that you don't need. So my advice generally is to avoid public discussion of public business on Facebook. Online meetings, we're not at a point yet where you can have a, quote, online meeting. You still have to have a quorum in one place, physically in one place. You cannot all be at your homes and go online and conduct a meeting that way. You can, I think there is some support for the idea that you could, as long as you have a quorum in one location, somebody else with the permission, I guess, of the board, if it permits it, somebody can appear by telephone or in that way, but not unless you have a physical quorum in one place. It applies to workshops where the commission is talking to each other. Now, this, of course, is a workshop. Does this have to be held in public? Not necessarily, as long as there's no there's no communication between and among you, then it's really not required. I always tell people the better policy is to conduct any meeting in the public unless there's a reason not to do it publicly. That fits within the very few exemptions that occur for the Sunshine Law. Attorney-client meetings. You have a city attorney, and she will give you advice from time to time. Now, there are very narrow circumstances under which you can meet privately with your attorney. Now, usually in the private sphere, this is really a dramatic difference from the private sphere, because in the private sphere, attorney-client communications are almost always private and confidential. But since you are public servants and you have a public attorney, most of the time she's going to be advising you that needs to be done in a public meeting. Now, the most common exception to that is if there is pending litigation. If there's a lawsuit going on, not one that's threatened, but one that's actually been filed, then there is an exception for discussions about strategy and so forth that might occur in that context of the lawsuit, and that can be held in what is called a shade meeting. But even then, you've got to give notice that you're going to have that kind of a meeting. You've got to record it, and at some point in time, it's going to become public record. There also is an exception, I think, for like labor management negotiations. Those sometimes can also be held in an out of the sunshine meeting. Advisory boards. Your advisory boards in this city, as in any city, are most of the time going to be covered by the Sunshine Law, even though they may not have formal decision-making authority. They may just be giving advisory opinions or giving voting on recommendations to give to the full board or to the mayor or to the manager. Those boards will generally have to operate under the Sunshine Law, even though you've got citizens who didn't run for office. They're going to find that they are covered by the Sunshine Law. Community forums. Can you go out to a homeowners meeting, let's say, and there's a member of your board also present? What is that? Can you both talk, or do you have to be quiet? What the opinions have generally said there is that's permissible for two people to be present from a board, provided they don't engage in two-way discussions between themselves, and if they're asked by, say, a citizen or a question, they can respond. I always suggest, and you don't have to do this, but I always suggest, just as a cautionary thing, to avoid an appearance even of sunshine law problem, that if there's two or more people present at one of these meetings, and of course, assuming this has not been advertised as a public meeting, if it's advertised as a public meeting, then you got no problem. But if it's not been advertised as a public meeting and there's two people or more than two people present from the council, I think the better practice is for one of them to leave the room when the other one's speaking. You don't have to, as I said, you have to be careful not only to follow the letter of the law, but to try to do what is going to instill the most confidence in the public in your performance, and that the public knows that you're abiding by the sunshine law. So I give that advice only because I think it can avoid problems that can occur when two people are in the same room and somebody suspects that maybe they're covertly or secretly trying to communicate. Staff meetings. I assume your manager has meetings from time to time with your various department heads, maybe in his office or someplace in the city. Now, the sunshine law only applies to public boards. It does not apply to individual administrators. So your city manager or your department heads, they are not personally covered by the sunshine law. They can have all the conversations they want. They can even talk to individual council members. That's not a problem. The only time that becomes an issue is if, let's say, the manager or the council created an informal committee among your staff. In other words, if you tell your staff to get together on a particular issue and talk this over and give me a recommendation, now you're creating a committee that, and if it's out of the the day-to-day responsibilities that the individuals have in terms of their regular duties, now you may have created a sunshine law board, and it may be that they're going to have to act like a board, even though they're not generally or not formally members of a board. The fact that they're put on a committee to advise the decision-making authorities about a particular matter, you got to be careful. You may have then formed a sunshine law board that's going to have to operate in public. Okay, what are the violations? The consequences. As I said, it's not a capital offense, but there are criminal penalties for knowing violations of the sunshine law. You can actually go to jail. People have gone to jail. You can be fined. More importantly, you can be removed from office at the discretion of the governor. And the governor, or at least the former governor, I don't know about this governor, the former governor I know did remove people from office who had been charged with sunshine law violations. Even though it's a minor criminal offense, second-degree misdemeanor, it's enough that the governor might remove somebody from office. So, again, not something that you want to even come close to. Even in a situation where it's not an intentional violation, it may even be just almost a mistake or just something that happened without anybody intending, can still be a non-criminal penalty. And it's never something you want to have happen if you're in public office. You don't want to be under any type of sunshine law violation. You don't want to be the subject of a news story about a sunshine law issue. And I will tell you that the media loves the sunshine law. They see it as a very important part of their ability to get information. And when there's a sunshine law violation, they inevitably get upset. I know back when the Miami Herald used to have money, they don't have any more, but when they used to have money, they'd run into court the next day if they thought somebody had broke the sunshine law. They would be in the court next day trying to do something about it. There are other consequences to it, such as the fact that if something is taken and action is taken in violation of the sunshine law, it's void ab initio, meaning from the beginning. It means that if you broke the sunshine law 2 months ago at a meeting and nothing ever was done to correct it, well, you might have to go back and repeat the entire process unless somehow there's been a full and complete discussion of the issue. And I will say that even though the spirit behind the sunshine law is for there to be public discussion of issues, there's no requirement that an issue be discussed. I mean, it doesn't have to be discussed. You can, you can just sit up there and vote, I guess. But the reality is that what generates a lot of complaints is when if people vote and there's a vote on something and nobody says anything, let's say, that creates a perception that there's been a deal worked out in advance, a perception of a possible sunshine law violation. Very unhealthy. What I tell people is, look, you don't have to say anything, but if you want to comport with the spirit of the sunshine law, if you want to act like a public servant who is trying to give the impression, or at least the best impression to the public about the fact that the sunshine law is being observed, then have a full discussion. Put it on the record. Don't be afraid to be completely open about what's going on. All right, public records. First of all, any questions about sunshine law? Yes.
Just a couple. Before I ask my question, I'm going to ask you, how do you cure a sunshine law violation?
How do you cure a sunshine law violation? Well, is there a doctor in the house? I don't know. There's not one particular prescription, but the courts have, and on occasion, held that even though the sunshine law might have been violated in certain circumstances, if there's a full discussion of the issue in a public forum. In other words, let's suppose there was a private discussion that took place, and it comes out that, but then it comes before the board, and there is a full discussion, and everybody talks about it and so forth, and there's a public hearing, and it's all out on the record. The courts will sometimes hold that, well, that was enough to cure the violation because there was a full, open discussion of the issue.
Okay. Second question is, a lot of time we go to conferences, and we could be walking down the street together and say, wow, this city has a nice monument, this would look good for the city of North Miami. Discussion, then before you know it,
right,
council meeting,
right.
Well,
that can be. I mean, I'm not saying you can't, go to an out of town meeting or accompany other elected officials, but I think you got to be careful. I think you got to be careful to avoid that kind of discussion, where you actually start making comments that are going to relate to something that might you have an expectation or a foreseeability that it's going to come up for a vote at some point. You need to avoid that. That's not the most serious violation I can think of, but it's something that you need to always be aware of when you're in the presence of another elected official on the board and you're not in a public meeting. Just be aware that you need to consciously avoid talking about anything that might lead you in that direction. That's what the sunshine law requires.
Okay. If a homeowners meeting is advertised, it's going to happen on Thursday at 6 p.m., but it never mentioned that council members would be present, and we happen to be present, and discussions come up, we make statements at that meeting. Is that a violation?
Well, as I said, it's not necessarily a violation regardless of whether it's advertised or not, as long as you're not talking to the other council member. If you're addressing the public, you're allowed to do that. Now, it's better, I think, if that meeting was advertised as a public meeting, and as long as it was advertised as a quote public meeting, I think it helps that it makes it much better from the standpoint of you're at a public meeting that was advertised. But I understand your point is that, well, the advertisement might have nothing to do with the presence of an elected official. What you can do, of course, is if you and several other members of the board are going to be at a particular meeting because it's an important meeting, well, why not advertise it as a public meeting by the city, and provided you're going to be allowed to the group that's holding the meeting is going to permit that to happen. But you can go ahead and advertise it because you're going to be there with other council members. Why not advertise it? That way you can have the discussion you want to have if it comes up.
Okay, thank you.
I have a follow-up question.
Yes, Madam City Attorney.
Yes, so the conference issue or homeowner issue,
Mhm.
and it's advertised, but there's no recording. At these types of events, they may be there, but there's no recording.
It doesn't have to be a recording, but there needs to be minutes.
Or no
I mean,
minutes.
well, if it's going to be fully in compliance with the sunshine law, you got to have somebody taking minutes, obviously, at least as to anything that's being said by the members of the elected officials. Excuse me?
At a conference?
Oh, no, I'm not. We're talking about at a meeting of say a homeowners meeting, which sometimes there'll be minutes of that anyway. There might be, but if you're telling me going to a conference, you shouldn't be having discussions at a conference. And the other thing is to be careful. Is that if you go to a conference outside of the county, even if let's suppose you were going to go to Orlando for a conference, and let's suppose you advertised that the North Miami City Council is going to be at such and such a hotel in Orlando, and we're going to have a meeting there. Would that be legal under the Sunshine Law? No, because the courts have said if it's they haven't really firmly established a distance, but they have said over 100 miles. It ain't a public meeting, because it's not realistic that people from North Miami are going to travel all that distance up to a meeting. Now, if you had a meeting, down in Miami, that might be different. That might be okay.
No,
Yes.
We have an issue that may come up. There's a couple members that may be traveling to a location, which I'm going to be, doing a seminar there. So I'm not sure exactly.
They can go, but just refrain from discussing public business. That's all. They got to refrain from discussing that in each other's presence.
Okay, but do we need to notify?
Not if they're not going to talk about public business. They don't need to notify anybody. No. Yeah, as I said, you can discuss something outside city business anytime you want. That's not a problem. All right. Any other questions? Sunshine Law. Okay. Let's talk a little bit about the public records law. I won't spend a lot of time on this because presumably your city clerk is the one who handles most of these issues. But just be aware, the public records law is a sweeping law. It covers just about anything that could communicate information about public business that goes across your desk, no matter what it looks like, whether it's a photograph or a tape recording or whatever it is. Those are public records that need to be maintained by the city, or either by a custodian or by the person who has custody of the record in case there's a public records request. And there is really no privacy issue there. There are people that think that, gee, this is embarrassing, that, this information is kind of embarrassing. Do we have to give it out? Well, there's no embarrassment exception. There are some exemptions, and I'll mention some of them in a minute, but just because it's going to be hurtful or damaging doesn't mean that it isn't a public record. What I used to do at the state attorney's office, when we would get, of course, our closed investigations would become public record, and sometimes there'd be some pretty incendiary stuff in that. And if I was going to release that, before I did, I would probably call the person involved and say, look, somebody's made a public records request, and I'm going to have to give that out. If you want to go to court and try to block it, I'll give you a couple of days here. I'll give them at least give them the decency to know that it's going to happen. But at the end of the day, most of the time, that information's going out. Okay. Anybody that's got custody of a public record has to allow the records to be inspected. Now, I understand you probably have a custodian of record. It's probably your city clerk, who generally responds to city to public records requests. But if the city clerk might not have all of the records, you might have some of those records, in your computer or in your desk drawer. And if you get that public records request, then you have a responsibility to make sure it is responded to. You can't just say, well, it's not my job to do public records. There was a city manager in a different municipality, again, I won't mention the name, that thought that since he wasn't the city clerk, that he didn't have to respond to public records requests, and he ignored public records request after request. He just ignored. At the end of the day, he got charged with a criminal public records violation, and he lost his position as a result. Okay. The generally thing though is it should be something that that communicates information or knowledge of some type. Now, an exception to that would be let's suppose you have notes. You are writing a report or some kind of presentation or a speech or whatever, and you make notes and then you do a rough draft maybe, and then do another draft and another draft. If it's only something that you yourself are going to look at and you're not passing the rough draft around to anybody else, well, that's really not a public. Those early drafts are not public record because they're not being used to communicate anything. They're just for your own personal use, your own benefit. But if you were to circulate a draft report around to other people in the city to look at, Now you created a public record. If you have, let's suppose one of your city departments is putting together a report, and that report goes through several drafts, and they pass it around to different people for comments and so forth. When that happens, basically they're creating a public record that each draft of that report must be maintained as part of the public record. In case somebody says, I want to see the prior drafts, not just the draft that went out in public, but the prior drafts, they would have a right to see those, so those need to be maintained. And that's really what this case said here, that inter-office memoranda and so forth, even though they're not part of the final report, they are still evidence of knowledge that's been shared or been passed around, and they become public record. Okay, and so I think I've covered a lot of this already, but as I said, notes and drafts, if it's just for your own personal use, not public record. If it's being circulated, it does become public record. Written versus oral requests. Suppose, and I don't know, maybe your city clerk people could tell me, if somebody comes into the city of North Miami and says, I want public records, do you have a form that you have them fill out? All right, suppose I came in and it says, I don't want to fill out your form. Are you going to give me the record?
Yes.
Yeah, you are, yes. Yes, because even though you have a right to ask somebody to fill out a form, there's no requirement there's no right to require that they do that. They can be anonymous. They don't have to give you their name, or they can just say, look, I want the record, and I'm not going to fill anything out, and that's absolutely permissible. And that public records request is just as legitimate as if they filled out your form.
We file an internal document.
Mm-hmm.
Even if a person does not want to do it, my staff does.
Oh.
Even though the person does not want to do it, my staff does.
Right, but what do you
they're
put?
not required.
Right, and what do you put on that form?
Well, if they don't want to give their name, it's John
Right.
Doe or
Don't
Jane
have to.
Doe.
They don't have to give their name.
Yeah,
sure.
we just say John Doe or Jane Doe is simply lets me know that anonymous male, anonymous female came in. It's just for my records to maintain.
All right. Now, emails and computers. Now, I don't know. Do you, as elected officials, have city-issued computers? Do you got a city-issued computer? No, the city gives you a computer to use for public business? All right. And I presume that you probably also have a home computer. Most of you would. All right. And now on your public computer, okay. And I don't know if you have this or not, but a lot of public computers there'll be a tagline that'll say, anything you see here is a public record and so forth. Let's suppose you engage in some personal communications with your family, with something that has nothing to do with city business, but you do it on the public computer. Probably you shouldn't do it, but that's not my issue here. But then somebody says, I want all of the emails on Mayor Pierre's public computer. Would they have a right to see your personal emails on that public computer? You think so?
They have gotten it.
They have gotten it.
Yes.
All right. Well, I'm not going to ask you what was on there. No, but the fact is that personal or private emails even though it's on a public computer, are not public record. All right. The only thing that's public record are things that pertain to public business. That's public record. So you do not have to, even though as a general rule, I would suggest don't use your public computer for private emails. It's probably a good policy to follow. It doesn't create a public record if it has no relationship to public business. Now, on your home computer, all right, let's suppose you get a constituent that communicates with you, probably Mr. Johnson, you probably get these emails from time to time, do you? The people. You don't. Okay, all right. Well, some of you do. I'm sure some of you, your constituents or your friends, have your personal email, and they'll send you stuff on your email. All right, but that's on your private home computer. Is that public record? It is. It is. If it's on, no matter what computer it's on, if it pertains to public business and you're a public servant, bang! It's a public record, and I can tell you it creates issues because partly it's sort of an honor system if somebody asks for that. But I can tell you, if somebody gets an email trail, let's say, and it shows that somebody's involved in, and they make a public records request and they don't get that email, now they know you're holding something back. They go to the state attorney's office. The state attorney's office could issue a subpoena to get all of your personal emails and go through them. Now, I used to tell people when I was at the state attorney's office, I don't want to go through your personal emails. I really don't. But if you make me, I'll do it. I mean, if you know, so that's why the general advice that I would give is try to keep the public business on the public computer and try to avoid it on your private computer, because you're creating public records, and that can lead to trouble. Yes, sir.
Yes, if someone sends an email to your private account, but you don't reply to it, is it still a public record?
If it pertains to public business, it's still a public record.
Like, for example, they sent it to the wrong email address.
The wrong email address.
Well, they sent it to my personal one instead of my work one.
Right, but if it has to do with public business, is that right?
So then,
And you're a public servant, and you got it. It's a public
retain to
record.
the.
Sure.
So then you're obligated to keep it for.
Yeah, now what you might want to do is you might want to
purposes.
send it from your private computer to your public computer. That way it's retained there, and then you don't need to worry about your private computer being invaded, as long as if you send it to your public computer.
It was more in reference to the retention.
And
That's the retention period.
Right.
That's
Well,
what it was
the
about.
retention period is, there's and your city clerk will have this information. There, the Department of Library and State Services at the state of Florida does keep a schedule of what types of emails need to be kept for, or what types of records need to be kept for periods of time. So it might be 5 years, it might be 10 years, it might be 90 days. Transitory emails, such as, we're going to have lunch at 2 o'clock, or something that has no real value, does not communicate anything substantive. They really don't have to be kept even. I mean, those are of no real value, and beyond a couple of days, I suppose. But there is a schedule as to how long certain types of records need to be kept. All right. The records transferred, like the judicial records, really do not even, they don't come under the public records law. They come under the state administrative judicial rules of administration. And as I said already, there are retention schedules that you can get from the Division of Library at the state of Florida. Exemptions, there are some very strictly construed exemptions to the public records law, active criminal investigative intelligence records, but at the end of those investigations or those criminal cases, all those records become public, at least in state court. Now, federal court's a whole different thing. As I said earlier, federal government doesn't have the constitutional right in there, and it's a much different situation. You try going to the FBI and asking to look at all their closed files. See where that gets you. They do not follow that prescription. But the state attorney's office, any police department, if it's a closed matter, it becomes a public record. There is an exemption, of course, even for Commission on Ethics, and our investigations, while they're ongoing, they're going to be confidential. Once they're closed, it's all public record. There are exemptions for things like medical records and student records and Social Security records and so forth. Attorney-client records, different here, because if you've got a city attorney, again, a lot of that's going to be public record. A lot of any opinions you get from your counsel, unless it falls into a narrow exception and involves advice that you might be on a pending case or something like that, most of those records of your attorney are going to be public record also. And then there are fees which are set by state statute. I won't get into that much, but they are. I do get concerned sometimes about how people that want public records get hit with $5,000 bills because somebody says, "Well, we're going to have to spend 100 hours doing all this research and so forth." I'm concerned often that is an abuse, but you are permitted to charge for when there's extensive use of clerical labor. Public records can be criminal penalties can be invoked. In the civil action on public records, you get an immediate hearing. It goes right to the top. You don't have to wait for a hearing. Somebody files a public records lawsuit, they get an immediate hearing, and if they prevail, they get attorney's fees. So for some people, those can be very lucrative. And I always say that on public records issues, don't make the decision yourself. Speak to your city attorney before you make a decision whether something's a public record or not, and it will save you, in the end, a lot of grief. Okay. Any questions on public records? Yes.
A lot of questions.
Uh-oh.
This is Public Record City. When I came on board, I guess. This is Public Record City. When I became the city manager, I found staff not doing, I don't want to say they weren't doing the job. They couldn't do their job because they were so busy answering public records requests that it interfered with the day-to-day operations of the city, to the point that the law itself scared people. I got to get this out. It says you got to do it reasonably. And I had, from media to residents, I want this tomorrow. And people would literally stop what they were doing because either they were afraid of the law. What do you constitute as reasonable?
There is no given time period that's considered reasonable. All right, the law doesn't say, X number of days or hours. It really has to do with the particular records involved. Now, I'm going to tell you, it's not a bad idea to be afraid of the law because it's a serious matter. People ask for public records, they're entitled to get those public records, and they shouldn't be made waiting for an unduly long time. Now, I realize it may not be reasonable for them to get them the same day or even maybe the next day, but somebody needs to get on those records and get them out, particularly if they're right there, if they're available. Frankly, those should be going out within a day. That's my opinion, all right? Because it's not reasonable to have somebody wait a week when it's just a few pages and it's readily available. If it's something that requires somebody to go into the archives and find and so forth, or go to another location, sure, maybe it might take a week or two to locate. But my advice is to be expeditious about providing public records, because if a court looks at it and they say, we don't think it was reasonable for them to wait 45 days for these records, we're going to charge you all their attorney's fees, that's going to be costly for the city. So it's not a bad idea to be concerned about public records and to have people respond rapidly.
Yeah, I just found that, when we got reporters, I need this by 2 o'clock. It's my deadline. And staff puts down what they're doing. I mean, really, I put in some measures in place, and I'm not bashful about it, but we'll get to it, and would it be reasonable? I've checked with other entities in other cities, and I found us to be a laughing stock because they says, what? That's we give it to them reasonable, but not the next day. And I'm talking about stacks of papers where we were not even charging people.
Well, you have a right to charge.
Right.
You have a right to charge.
So, but it just got to the point where certain things were going out. It may have went to the city attorney's office. It may not have.
Why do records have to go to the city attorney's office? Are they not allowed to give out a public record without the city attorney's involvement?
Redaction, social security
if
numbers.
it's something other than a simple record, and if it has something in there that might need, I understand that, sure.
Right.
And that can be a reason why something might get held up for a few days if you have to actually redact some information that's not public. I think people should understand that. But if it's a simple record that that something that went on in a council meeting or something, that should be given out right away.
Right, and most things are simple in nature, but
What noise? What noise? No, I don't. Is there a problem with hearing?
Yeah.
All right. No, if anybody has a question, by all means, just put your hand up. We'll be happy to answer your question. Yes, ma'am.
excuse me.
No,
Okay.
my question was the same as
It's being
city managers.
televised. It's being televised, not on the microphone. They're working with
My question was the same as the city managers. What is a reasonable time when you do a public records request?
Right. There is no
It's not-
particular time.
It's not weeks, and you do expect to receive an answer.
I would advise against setting any arbitrary amount of time. Say we will give it to everybody within a certain number of days. That's not a good idea, because you're going to be judged on the particular request. Was it reasonable for this particular request to take 40 days or 20 days or whatever? So, and be expeditious about it. I mean, the spirit of the law is you provide it as soon as you can, and in a reasonable way. And you're doing a public service. You're doing something that's in compliance with the law and with the Constitution of the state of Florida. So don't take that lightly.
Oh, and I guess I understand. I'm changing internally. And like I said, I'm not bashful about it. I'm changing the policies where staff stops what they're doing because people want the last 2 years of this, and it takes time. I mean, we have a city to operate. There's budget constraints, and when people are not able to perform their regular tasks, it's because we're doing something that's beyond reasonable. Is what my concern is.
Well, it isn't in the law, and I can't tell you what a judge is going to say. But if it gets to court, the judge is going to look at this and say, was it reasonable for it to take this amount of time? And that's why the sooner that you provide it, the less you're going to expose your city to a judgment like that.
And the other one, the other question is when people want to sit down and view documents. Immediately. I normally am making it a policy that I want someone to be there because some documents have social security numbers, date of births, information that I would not want anyone to see. So that I'm reluctant to let people walk in and say, I want to see all these files, because some of them do have confidential information. And when that does happen, can we charge for that? I mean, is staff to sit down to watch someone? It's not a paper. They're not taking copies of it, but I've got a staff person there that is now got to sit there for hours while someone views documents. Can we charge for that?
My personal view is I don't think you should. Now, I can't tell you that the law doesn't allow you to. I mean, there it is right there. Reasonable special service charge for extensive use of a clerical or supervisory labor or information technology resource based on actual cost. Now, from that, it would seem to me that you might have a right to charge. But the policy behind the public records law is for these things to be made available. And I can understand if it's like 1,000 pages that have to be copied, and somebody has to stand at the copy machine. Now you're taking them away from their regular job, and it's for one person's request. It's not unreasonable to charge for that person's time. Personally, I don't like the idea of charging because somebody's going to stand there and just look over somebody's shoulder. I find that personally offensive, and an impediment to public records. That's my personal view. Let me say that very clearly. I'm not saying you can't, but I think that the public has a right to get access to records, and if you can do it in such a way that minimizes the cost and the hassle of getting the records, I think that is what the spirit of the law asks for.
I've checked with the other cities. Our turnaround time is probably the best in the state.
Well, then I don't know what it is, but if it is, then
yeah.
But it has to do also with the particular records involved. I mean, if it's just 1 or 2 pages and it's a simple matter to do, or is it 10,000 sheets of paper that have to be looked at and redacted? Those are very different situations. You could justify a month or 2 in some of those cases, but not if it's just a piece of paper.
Gotcha.
Okay. All right. We're going to move on now to the Code of Ethics for the. Robert here is going to talk about the agency that I'm involved in for a few minutes, and then I'll get back up here and talk about some of the key provisions. Let me just say generally that the Miami-Dade County has a Code of Ethics. It's been in effect for many years, and for many years it wasn't really enforced until 1996 when they created the Miami-Dade County Commission on Ethics. They finally got an enforcement agent, so we're there to enforce it. Now that that county ordinance is applicable not only to county government, but it's applicable to every single city or municipality, town or city in Miami-Dade County. So you are bound by the county ordinance. Now, some of you, including this city, have your own ethics ordinances, city ordinances, which is perfectly all right. But the general rule is that your ordinance cannot be less restrictive than the county ordinance. It can be more restrictive, but it can't be less restrictive. So if the county requires certain things under, let's say, gifts or conflicts of interest, you can't make it looser or less strict. You can make it more strict, and that would be enforceable. In fact, my agency will enforce your ordinance. As I recall, your ordinance provides for a procedure for the city attorney and maybe the manager can enforce it. I don't know that happens as a practical matter. Do you ever get? You don't. But we are empowered by county ordinance to enforce your ordinance as well as our ordinance. So it's more likely that we would be the ones enforcing the city ordinance. And what I've done when I get to some of the specific provisions, and you will not get this anyplace else, I've spliced together the two ordinances so that in some cases I'm going to talk to you about the county ordinances, but in a situation where I saw that the city ordinance was a little stricter than the county ordinance, I'm going to give you the county ordinance, so the city ordinance rather. So I've kind of spliced them together because you really have to look at both things. All right, Robert.
Good evening. A lot of times you go places and we say, "Oh, I'm happy to be here." And if you've ever been in the military, there's a scenario where you have a first sergeant, you have the inspector general, and a company commander. And the company commander says, "We're glad you're here." And then the IG says, "We're here to help you." And that could be farthest from the truth because they're both lying. So when I say I'm happy to be here this evening, I'm thanking the mayor of the city of North Miami and other commissioners. I'm going to get through this, and primarily we are a resource for your organization. We are proactive. We do not have a siege mentality. The only time people think we have a siege mentality is if they have been given false information or afraid to speak to us. So having said that, there are a couple of documents in the back. Should be might want to take one. One is this little green flyer. It kind of gives you a brief synopsis of what we do, who we are. That way you don't have to read this. Okay? Now, if you want to, you're more than welcome to, but it gives you a short synopsis of how we came to be and what we do within Miami-Dade County. Mission and responsibilities. Pretty much we were created, and I always tell people, read the Home Rule Charter. If you do not know what it is, it's how Miami-Dade County is governed. They have the Home Rule Charter, and that's how we were created. Our ethics, we have a threefold mission. We do rendering of opinions, training, and outreach and enforcement. Now, most people know us, and they look at us from the enforcement phase, but we pretty much do a lot of outreach, and that's what we're doing this evening. In terms of, again, the organization, outreach, opinions, and enforcement. As Mr. Senorino stated earlier, we have jurisdiction over all county employees and the municipalities. What a lot of people don't know is that we do brief advisory boards at the county, but we provide the same briefings to advisory boards within cities, but you have to ask us to come out and do that. And that the state attorney's office has concurrent jurisdiction with us in the ordinance. So a lot of times people say, well, we send it to the ethics commission. They don't do anything. It's not within our jurisdiction. You think we let it go? No, we send it to the appropriate entities or agencies so that they can further take action, especially if it's out of our jurisdiction. And one of the things people get angry about, we do not have an ethics jail, okay? We can't arrest you. We can't arrest people on their appearance of impropriety, because if we did, well, jails be full, and we probably wouldn't have enough people to run the city, and so on and so forth. And then for those of you who are thinking about running for office next year, we are doing a campaign skills seminar in Miami Gardens on the 18th from 6:30 to 8:30 at Miami Gardens City Hall. Wouldn't it be nice if you walked into a room or a job and you can just look and see all the bad ethical violations? That would be great in a perfect world, but of course it doesn't work that way. We're going to talk about advice giving, and I'm not talking about, gentlemen, I'm not saying go to somebody who's been married 5 times and ask them how to keep your marriage going. What we're talking about advice giving is this. You are an elected official. You have an issue that you do not know whether it's an ethical dilemma that you want to resolve. When we talk about inquiry, an inquiry is just a short version of getting you an answer back within a 24 to 48-hour window. We meet on a monthly basis, but we say we've done so many opinions that we have enough legal precedents to kind of get you an answer in a hurry. And that's what we always try to do, regardless of what it is. Now, if it's a request for opinion, and it's something that we have legal precedents and with 10 to 12 years of legal opinions, we can go and we can still get you an answer. But with the opinion, it's a little more complicated. If the issue is complex and it has to go before the ethics commissioners, then we do that. But the inquiry is to get you an answer, to get you moving, and not to slow up your process. When we say request for opinion, a lot of times people give you very limited information. The response that you get when you do a request for opinion can be no better than what you put in your request. So, you know, like some kids, you know, they come home and they tell you, Mom, I got kicked out of school today, but they forgot to tell you they got in a fight and they started calling the teacher names and so on and so forth. So based on what you put in that request, that's going to make, you know, how your opinion comes back. And note in your request if it is time sensitive. Sometimes people have issues that they need an answer right away. It's time sensitive, but they don't tell anybody. And if we know it's even more time sensitive, we do our best. And as Joe previously mentioned, past responses, once they're completed and opinions are done, they're public records posted and searchable on the website. So there are people who have sent us requests for opinions. Why'd you put it on the website? I can't believe you did that. Well, it's a public record. We have an obligation to do so, and we do. Don't let a friend cause you to become an inmate. Sometimes loyalty to our friends causes us to make those decisions that we wish we could undo. And we always talk about the simple fact, ask yourself, are you willing to trade places with the individual that's an inmate? 9 times out of 10, most people don't want to. What I didn't talk about, and I want to back up here briefly, are how our ethics commissioners are appointed. 2 are appointed by the Chief Judge of the 11th Judicial Circuit. 1 is a shared appointment from the St. Thomas Law School and University of Miami Law School. Another one is appointed by FIU's Labor and Research Center. And another one is appointed by the Miami-Dade County League of Cities. This is just kind of a short brief in terms of what we do in outreach and education. I can say for the last 2 years, I can count that we've done pretty much more than 550, almost 600 briefings in the last 3 years throughout. I'm sorry, close to 800 because we did 415 in 2009 and 10, and another 400. We missed 415 by 1, and this year we have been extremely busy. But this is a scenario we do it for elected officials, board members. There are. I don't know if it's impacting anyone here, but if you are a lobbyist and you're going to lobby Miami-Dade County now, there's a requirement for you to take a lobbyist class with our organization. If you're running for office, the CSS, i.e. Campaign Skills Seminars, we do briefings for nonprofit organizations, businesses, civic organizations, and we're in the schools doing doing some issues with students because we have a program called Model Student Ethics Program that talks about critical and analytical thinking. Now, if this gentleman looks familiar to you, it's probably because the guy sitting off to his immediate left looks like a sitting mayor. I could be wrong. But, oh, that's the other guy always working. Request for opinions. This is just a quick synopsis. I always use this because, one, most of the opinions we get revolve around doing business with one's government and voting conflicts. And if you note, 82 and 81 are those particular numbers. Inquiries, like I said, are those things that you get answers to in a hurry, and it's just a myriad of different things. Gifts, voting conflicts, doing business with one on government, financial disclosure, and so on and so forth. Enforcement. If we get a complaint, we have an obligation to respond to the complaint, or at least take a look at it, if it's within our jurisdiction. Again, if it's not within our jurisdiction, we send it to the appropriate entity. A lot of times people don't realize it, but we do have subpoena powers. Okay, so while we might think we're a paper tiger, we're not. Once the complaint is filed, you have a determination of legal sufficiency, meaning there's enough opinions in there that says we can look at this. But here's the problem when people file complaints. They only give us, on occasion, half of the information. They don't give us the full tilt. And then what they do is they run off and they file with media and say, oh, we filed a complaint against Commissioner so-and-so or Mayor so-and-so. They just filed it. We don't confirm or deny. And if there's no legal sufficiency, it gets dismissed. But by the time it gets dismissed, they may have already gone to the media with the issue. If there's legal sufficiency, there's a probable cause hearing. No probable cause, it gets dismissed. And if there is probable cause, it moves on to an investigation and so on through the appellate scenario. Complaint becomes public upon finding of probable cause or upon dismissal or final resolution. Not going to ask you to read that because I can't. But basically, this is just what I described to you. And you can email, you can snail mail, you can hotline, you can pick up the phone. A lot of times people want to send email anonymously, and I always remember this because it was my first year with the organization. Someone sent us a complaint via hotline, which makes it anonymous. And they called back 2 weeks later, and they were angry because it had been 2 weeks and no one responded to the complaint that they filed. So I put them on hold, and I laughed and laughed, and then I got it out my system. And I said, we would love to have responded, but you filed your complaint anonymously without a name, and we had no way of getting in touch with you. And we always tell folks, if you're going to file a complaint and you want it to be anonymous, don't fax it from your desk. Some people just don't realize we see that. Pretty much that's all I have to say, but here's the bottom line. Our resources are available if you've got organizations that you want outreach to come out and speak to them. I'm going to tell you our secret. I do work on Saturdays. We do briefings after 5 o'clock, so we're not an 8 to 5 go home kind of organization. At this time, our services are currently free because the county pays us to come out and do these things. So if there's anything we can do, and I sincerely mean it in terms of positive, proactive issues with your city or organizations, please feel free to give us a call. Okay? Thank you.
Question.
Yes, sir.
After your investigations, are the names of the complainants ever disclosed? After your investigations, are the names of the complainants ever
Let you take
disclosed?
You can take that.
If somebody has filled out a complaint and their name is attached to it, yes, then it becomes public record. Now, can somebody make an anonymous complaint? Sure. If somebody calls us up and says, "Look, I don't want to give you my name, but you need to know this is going on," and they have enough information that it needs to be investigated, then we'll assign it to somebody to investigate. We may not know the name of the complainant, so there's really no record of it. So that could happen. But if somebody signs a complaint at the end of the process, their name will be part of the record. All right, I'm going to go through a number of the ethics ordinances, both the county and the city, some of the city ordinances as well. I try to just make the point at the beginning, though, that this code of ordinances, this is only the minimum standard of conduct for public officials. Now, it tells you cannot do certain things. It doesn't mean that simply because you can do them that you should do them. There are a lot of things that are permissible legally and even under the ethics code, but are really stupid and that you shouldn't do. All right, and to some extent, you have to use your own judgment in a lot of cases. Because, particularly if you're in political office, you have to realize that, your political opponents are going to pick up on things that you did. It doesn't make a difference whether it was violation of the Code of Ordinances, but if it looks bad and that creates a bad appearance, we don't have a ethics ordinance that says it's unethical to create an appearance of impropriety. That's not something that we can charge somebody with or fine somebody for. But that really is the one of the standards you ought to always have in mind. I mean, is this going to look like a problem? Is it going to something that's going to undermine the public's confidence in the integrity of government? Because if it is, you ought to think about not doing it. Because that we have that obligation, and it's not just it's a question of you're applying your certain values to the work you do, and making decisions about what's the right thing to do, not just what's legally appropriate or what's legally permissible, but you should aspire, I say, to a higher standard of ethics than the minimum standard, which is included in the ethics ordinance. All right, I'll talk first of all about those of you who have gotten into public office. You find out soon enough that you become popular, and sometimes people want to give you things. And not a good idea to always take these things, and at least it's a good idea to have your eyes open and to know what the going the wrong way here. Okay, because oh, all right. Sometimes the difference between an ethical issue and a criminal issue can be a very narrow one. And I use as an example of when does a gift turn into a bribe? Because the difference between an ethical issue that's raised by a gift and a felony bribery, sometimes it can be that much. And so it's a reason to steer clear from this whole area. When there's a quid pro quo, that's the answer. I mean, which literally means what for what. It means there's got to be an exchange. Not just a gift that you get, but you're agreeing to give, or you're giving something in exchange for that, and with some understanding that there's a public servant who's giving some public action in exchange for some private benefit. We had a case in the state attorney's office a few years ago involving a guy at the airport who was. He was in charge of telecommunications, and there was a small firm that kind of wanted to get into, some being a subcontractor on some of the big airport contracts. And I think it started out with they just introduced themselves to this guy and said, we're a good company and blah blah blah, and they took him out to lunch or something, and I think the intent from the beginning was just to see if we can get in there and get to know these people, and maybe we'll get some business. And they did get some business, and then they kind of, they kept going a little further. They took him out to dinner, and then they gave him World Series tickets, and then they bought a golf outing for him, and not big ticket items, but over the course of a period of time, they're getting all of these contracts, and this guy's getting all these freebies. Suddenly somebody put the two together and said, wait a minute, this is bribery, this is unlawful compensation, and he ended up going to jail. I think he started off thinking that this is just harmless. I mean, this kind of thing goes on in the private sector all the time. People will give favors to each other, and nobody thinks a thing of it. You get into the public sector, you're in a different world with different rules that apply only to people in public service. Keep that in mind. The rules are there for you. And you're not you're not an entrepreneur. You're not a business person. You are a public servant, and there are expectations and rules that apply to you and to nobody else. And I've seen many situations develop into what I thought were relatively innocuous situations turn into criminal or felony bribery. A little bit more on that later. But first of all, there's a gift ordinances, and in most of these situations, the county code and the city code are very close, but in some cases the city code is a little more specific or a little more strict. So in some cases I'm throwing in the city code, and here's one of them. Okay, what is a gift? What is the definition of a gift? First of all, it's something that you get without adequate or lawful consideration. It's something you don't pay for, or you don't pay market price for. You get for less than what it's worth. That's a gift. Okay. Could be in the form of money, service, loans, travels, hospitality, anything like that you don't pay full consideration for. That is a gift. Now, there are certain things that are exempted from the gift ordinances. Political contributions, covered by a whole other set of laws in the state of Florida, but they're not considered gifts personally to you. They're considered contributions to your campaign. Gifts from relatives or household members don't come under this. You get an award for your community service or something like that. That's not considered a gift that you need to be concerned about in this context. Something that's an advertisement, you go to some of these trade shows or whatever, and people will give out pens or something with the name of the company on it. That's not what we're talking about here. There's also, and this is in your ordinance, gifts made to the North Miami Employees Assistant Trust Funds. I don't know what that means, but the North Miami Police Athletic League, or a recognized not-for-profit organization. If you're involved with a not-for-profit organization, you can, accept a gift in that context, and presumably it's not going to you personally or to your personal benefit. Those are not part of the so-called gift ordinance. All right. Now, the solicitation of gifts and acceptance of gifts. Let's talk about solicitation here for a moment. When may a gift be solicited? And the easy answer is never, or almost never. In fact, there's a city, or there's a county ordinance which says, and a city ordinance that says, you may not solicit any gift. All right, so asking for a gift is dangerous. There are a couple of, and this is in the county ordinance, not in your city ordinance, but I think probably we would apply this. There are a couple of situations where it's recognized that it's not a problem. If the city or the county employees or officials are soliciting a gift for the city, all right, it's not going, nothing that's going to anybody's pocket or anybody's private home or personal benefit. It's something for the city. Generally speaking, you can solicit something for the city's benefit. And then, if it's a nonprofit, and this is in your ordinance, but if it's a nonprofit organization and you're not getting any compensation from this, you can solicit those gifts. But be careful in here. I mean, particularly if you're. I would advise against, going to vendors or city contractors and hitting them up for contributions. I don't think that's a good practice. I think that leads itself to an inference that you're looking for them to give the city something in exchange for getting their contract renewed. I think that's not. I mean, if it's offered, that's different. But if it's solicited, I think it's bad business, and I would discourage anybody from ever soliciting a gift from anybody who does business with the city. Yes, you had a question.
Okay,
You're a member of an association. Go ahead.
Right. Say, for instance, an affiliation to your job, and you were requesting like donations for a conference that you're putting on for the benefit of the association, the members.
Mm-hmm.
Would that be considered?
I think it would be a better idea for association members who are not public employees
but
to
they
make
are
those.
all public employees.
They're all public employees.
Right.
They're all public employees. Well, who are they going to ask? I mean, are they going to solicit from the general?
From vendors.
I don't think that's a good idea. I think it's a terrible idea. I think it has ethical problems written all over it. A city vendor gets a call from a city employee or a city official saying, we want you to contribute to something. I think it's bad business. I would recommend strongly against it. Now, if you have people in an association that aren't connected to the city and they're the ones that are going to make that solicitation, I think that's different. But I would avoid creating a perception that the city is asking somebody to donate when they have business with the city.
Well, you're actually going in the name of the association and not the city. Say, for instance, like a public risk management association, where you have bodies of risk managers that represent entities are members of. So actually, you're under the auspices of that organization and not representing your entity, so to speak, in that capacity.
I understand. I said I would avoid it because I think it's fraught with problems. Now, it doesn't mean you can't have a fundraising drive and advertise it, and if people want to contribute to it, that's different. But actually going to a city vendor and they know you're a city employee, let's say, or you're a city, I think that's problematic. That's all. I would advise against it. I'm not telling you that you're going to go to jail for that, but I'm telling you, I think anytime you're putting the arm on a city contractor or a city vendor to give something, I think that's a problem. That's a problem. Yes, sir.
I have. What about in terms of it, a contract? For instance, I have seen cities that have in contracts that we want you to participate in city community-involved events. I mean,
It's in the contract.
it's in the
Well, that's a
contract.
completely different situation.
Okay.
And in fact, if you've been following the ticket, we'll just call it the ticket controversy that's going on recently, we were mostly concerned about situations in that where a city, let's say, or the county, in a contract required that a particular vendor, or in some cases it might be the Marlins, that they give, say, free tickets to the city. That you can do that. I mean, that's fine. You can do that as part of a contract. Just beware, though, that whatever they're giving to the city, that's public property. That's not something that people put in their pockets. And the point we were making is that it's wrong for the city officials to take these tickets as though they belong to them. That's something that needs to be given to the public or used for a public benefit.
Okay.
But you certainly can require that they, and I know that they do this with developers, that they require that a developer, put some money into some public project, and you negotiate that. That's part of the contract. That's what part of what they're giving up for the benefit of doing business, and it's all in the up and up. That's transparent. It's out there. It's in the contract. They agree to it up front. So that's a completely different situation.
Because, I mean, that was the recommendation that I got from other city managers, is to put it in the contract.
Right.
So I was a little missing.
I think it's better for it to be in the contract,
contract.
than to be going afterwards and saying,
Right.
we want you to do this or we want you to do that.
Okay. Because I'm putting that in all of our contracts.
All right. No, then that's perfectly all right.
Up to what dollar value would public disclosure of a gift be necessary? Would you
Well, I'm going to get
recommend?
to that. I'm getting to that in a second. All right. Although there's a distinction between the county and the city on this. Anyway, okay, we talked about solicitation. Now, acceptance. Okay. The short answer is, again, probably we shouldn't be accepting gifts, but there are the law on this, and it's both in the county code and it's in the city code. It talks about, well, if it's you can accept a gift if it's not in consideration of an official action, or it's not in exchange for the performance of some legal duty or a violation of a duty. And your ordinance has this fourth one in there. It's not to attend or be absent from a public meeting that you accept the gift. Let me tell you, if you do any of those things, you're really committing a felony bribery. All right, because you're accepting something as a quid pro quo, as an exchange. So never mind the ethics ordinance. You're in deep trouble if you do any of those things. So again, that's not really a good ethical thing to follow. There are gifts that I think ought to be avoided. All right, and this is where we get into again to municipal vendors or contractors, developers, lobbyists, and I'm not talking again here about a situation where it's part of the contract. That's a different category. That's not a gift. That's part of the consideration of the contract. Okay, so don't even think of that as a gift. But there are state of Florida provisions in the state code of ethics. Now, aren't you lucky? You have a city code of ethics, you have a county code of ethics, and you have a state of Florida code of ethics that applies to every public servant basically in the state of Florida. So you got a cornucopia of provisions out there. This ain't easy stuff. I mean, and I don't think there's anybody that's an expert on all of those levels of regulation. There are a lot of similarities in those, but there are some, as we've seen, there are some distinctions. In some of the areas, the state will be a little different from the county. So it can be a bit of a minefield. I threw in a couple of state code of ethics laws here because I think that it helps broaden the areas that you need to be concerned of. Now, I mean, the law does not say you can't take a gift from a municipal vendor or a developer or a lobbyist. It doesn't say you can't, all right? But why is a municipal vendor or contractor or a developer or a lobbyist, why do they want to give you a gift in the first place? I mean, use your common sense, right? I mean, and look at the state of Florida Code of Ethics here, because this is not a criminal statute. This is an ethics statute, all right? But this really gets into, this is, you know, you certainly can't take something when there's an explicit quid pro quo, there's a deal. But this talks about, and I underlined it, with the exercise of reasonable care, you should know that it was given to influence a vote or other action in which you're expected to participate. Well, I'm sorry, but there aren't many times when a lobbyist is going to give you a gift as a public official and you don't know, or you don't have reason to know, that it's given to you to influence you. They may say differently. They may say, you know, you're just a great guy. Here, take these tickets to, the Dolphins game or something like that. But, you know, you with reasonable sense ought to know that these people in particular, these categories, these municipal vendors, contractors, developers, and lobbyists, their business is to influence you. You shouldn't be taking anything from them, in my opinion. I think anything you take from them is probably tainted and probably something that somebody could at least charge you with an ethics violation on. I'm not saying it's going to happen, and I'm not saying it's clearly illegal in every instance, but common sense should tell you avoid those situations. There is a state of Florida statute that says that you cannot take a gift in excess of $100 from a lobbyist. So there is a state law that applies. I would tell you, don't take anything from a lobbyist, but the state law limits it to $100. Okay, you cannot take travel expenses from city vendors, and this hasn't been in effect that long. Actually, it's sometime within the last 6 or 7 years. It was because of somebody taking trips to Europe to look at some plant there that this thing got passed. But basically, and this is in the county code, if you need to travel to do something, to check out some facility or something that a city vendor or a contractor is doing, the city can pay for it. You should not ever accept travel expenses from a municipal vendor. Okay, now disclose.
Something that the city can vote on waive. What is it? The last. I'm sorry. The last.
Oh, the last thing. Okay, no, you're right. Let me see here. The city council can waive the requirements. Yes, if there is a city council vote and said, in this case, we're going to waive the requirement and we're going to allow you to accept it, they can do that. They can do that. You would require a city council vote to waive the prohibition against a vendor providing travel expenses. Yes. Okay. Disclosure of gifts. And we go back now to the North Miami Code. Because I didn't see in there any threshold. Now, in the county code, it's $100. I know it's at $100. If anything over $100 has to be disclosed. But I looked at the city code. I didn't see any threshold. So to me, that means that it's more restrictive, and that the city code requires that you disclose any gift that you get, no matter how much it is that's given to you. Again, if it doesn't fall into one of those other categories, like from a relative, if it's from a personal friend you've known for 100 years, I don't think that's a problem either, frankly. But if it's somebody who knows you in your capacity as a city councilman or the mayor, and if it's somebody that, for instance, is grateful for you doing such a great job, and they say, here, I'm going to give you this. If it's something, you can't accept something from somebody, though, for having made a decision that was favorable to them. If you voted the way they wanted you to vote, and they say, gee, that's great, here's a free dinner for two at some fancy restaurant. Don't take it. That's a bribe. That's as good as a bribe. That's unlawful compensation if it's done in exchange or in consideration of something you've done in your official position. They say, I just like you, you're a good guy. I mean, there's nothing that says you can't take it. But just understand, if it's somebody that has an interest in the city, if it's a vendor, a contractor, a lobbyist, anything you take from that person, A, is suspect, and B, has to be disclosed under your own ordinance. And if you don't disclose it, it comes out later, you're going to be held in violation of the ordinance. Okay. I'm going to talk but I'm not going to go into this. This is part of a much longer. I give about an hour-long lecture sometimes on bribery, and I don't think I'm not going to go through that now. But just to remind you, first of all, that bribery is a very serious offense. It's so much more serious than an ethics code violation. It carries almost a mandatory state prison sentence. Since 2003, they upped the sentencing on bribery from what was a level 1, which is the least serious, from between 1 and 10 on the sentencing guidelines, to a level 7, 10 being the death penalty. So you get convicted of a bribery or the flip side of that, unlawful compensation, either one of those, you're going to prison, and it's very serious. And as I said earlier, the distinction between an ethics issue on a bribe and a felony bribe is a very narrow distinction that probably is going to be in the mind of the prosecutor. So you just don't want to be in that position. And this is part of a longer, as I said, I have a much longer presentation, 8 ways to bribery. I'm not going to go through all of them right now, but again, the number 4, the gift one is, in terms of ethics, is the one that you need to be real careful for. Remember the guy at the airport that took the lunch, and then he took the dinner, and then he took the World Series tickets, and before you know it, he was in jail. So be careful with that. Yes, sir. Sure, go ahead.
And you have pay to play, then you have campaign contributions.
Yes.
But prior to that, you says.
Well, and that's a good point. Let me explain that. Campaign contributions don't come under the gift ordinance, okay? Because they're not, quote, gifts to you. But you could have a bribe that involves a campaign contribution. If the campaign contribution is as a quid pro quo for something you're doing as a public official, you got a felony bribe. Now you remember you heard about the governor of Illinois, who's now doing 14 years in state prison in Illinois. He was on tape saying to people things like, well, they're going to have to ante up for my campaign or else they're not going to get this contract, that type of thing. That's bribery, okay? So you can have a bribe with a campaign contribution. It would have to be a real strict quid pro quo and with strong evidence, because obviously it's perfectly legal to take these campaign contributions. But if you ever conditioned a campaign contribution on, look, you don't get that contract, you don't get that job, you don't get that zoning variance unless I get a campaign contribution, felony bribery.
Okay. So pay to play. I mean, that's a big one.
You don't have to run for office, you know.
I'm not running for office, but what I do is, when I check with other city managers and I have to go back to the contracts, I mean, they tell me, a good way to keep things clean is to put in the contract that you want a percentage to, in other words, let's say you do a contract and you say, listen, we expect
campaign contributions?
Not campaign, but I want money to come back to my community.
Okay.
Community.
No, that's perfectly all right.
Right.
So
that's not a pay to play.
That's part of the contract.
Okay.
No. That's pay to play is a kind of a phrase that's used with campaign contributors. Like, hey, you want to play in this town, you got to ante up with campaign contributions. I mean, lobbyists typically, and again, it's perfectly legal for a lobbyist to make campaign contributions as well as to raise money. My own personal view is I think that is a fountain of corruption. To have a lobbyist whose professional work is to influence elected officials, be simultaneously in the fundraising industry to raise money for them, I think that's fraught with problems. And there are some places that restrict that. The city of Miami Beach restricts that. You're a lobbyist or a vendor down there. I don't think you can't. You're not allowed to raise money for the council down there. But it is permissible. But be careful. It's not a quid pro quo, because that's when you can get into a problem, a felony problem. Yes, Mayor.
To me, I just think. I just think that this is more appropriate for the people with the money rather than the elected officials. Because, I mean, I talked to many mayors, you know, council members. I would say 99% of us got into office with very, very good intention. And it just seemed to me that the people that are really driving the trend in town are the people with the money. And I think they probably need those kind of training and seminar. And
Well,
I'm not sure if it's required by your
Well,
office for them to
the
get it.
lobbyist course that I give to the city of Miami, I do a whole hour on bribery. So that'll make you feel better.
Okay, thank you.
All right. Anything else on this? All right. And I'm not spending a lot of time on this because, I mean, I understand it's not really the central core, but I wanted to touch on that. There is a section of the Miami-Dade County Code, and it's also in your local ordinance here, called exploitation of official position. This is what I would call a catch-all type of ethics violation, and it's a very commonly charged one because it covers a lot of ground. And it really has to do with any time a public official or a public employee uses their position to get some special benefit that they're not entitled otherwise to get. They're in violation here, and I mean this and this is an alternative to a criminal charge often. Although you should be aware that a county code violation can also be charged as a criminal misdemeanor if the state attorney's office decides to charge it. But this to me sums up the whole concept of ethics in public service. You're there to do, to serve the public. If you're somehow enriching yourself, somehow getting things that you wouldn't otherwise be getting by using your public position, you're violating the ethics laws. All right. When I was a criminal prosecutor, I used this as a criminal charge against the mayor of West Miami. And what the mayor of West Miami was doing was he had a city-issued cell phone, and this is before it was you could make a call anywhere for nothing. I mean, but and he ran up about $70,000 or $80,000 on the city cell phone calling his girlfriends in Santo Domingo over a period of several years. And then the company got tired of it and said, hey, in this last bill, you're going to pay this last bill. And I think it was $5,000 because they had just let it go. And he says, I'm not paying that. And he went to his city manager and said, tell them to make that go away. We, after all, we let them put their cell tower in our city. I shouldn't have to pay this. We charged him with a criminal charge under exploitation. He was removed from office and he was convicted, and that was the end of his political career. Because he was using his power as mayor to get a personal benefit. This use of not only the use of the cell phone, trying to force the phone company to relinquish the debt. Was there a question? Yes.
What about the use of the stadium? The $40,000, city staff, lights.
Yeah. I know what you're talking about, and as I said at the beginning, we're not going to here to talk about specific cases like that, because it's something that's under review and not something I'm free to talk about. But just generally,
it just doesn't look good. Exactly.
Well, the general rule is if it's a public facility, it needs to be used for public purposes. Now, the city or the county can set whatever rules they want in regard to how it's going to be used. But it needs to be used for a public purpose. It's got to be a public facility. Okay. The conflict of interest here, and there are There are probably 7 or 8 different conflict of interest provisions that are in and out of these codes. I'm going to talk about the main ones here. Transacting business with the city. Now, you'd think this would be kind of a common sense thing, but it happens. If you're a city official or an employee, you shouldn't be doing business with the city of North Miami. All right, and you shouldn't be somehow connected to any contract that the city is involved in, and you shouldn't, and includes your your immediate family members. It means your immediate family shouldn't be involved in any contract with the city. And if this is violated, not only is the contract get thrown out, but it's considered malfeasance. You can forfeit your position, and this is under your own North Miami code, you can get a waiver only by a supermajority of the city council if there are certain findings that are made at a public hearing. But the general rule is you and your personal family members do not do business with the city. There's another provision under the North Miami Code that basically talks about getting into any contract or transacting business with the city or a representative of the city through another entity, through a business entity where you have a controlling financial interest defined as 10% or more. Now, I mean, you might have stock in, I don't know, IBM, and maybe IBM has a contract with the city. That wouldn't come under this because you probably don't have 10% of IBM. If you had 10% of IBM, you wouldn't be running for office here, probably. If you own 10% or more in a business, then that business can't be doing business with the city of North Miami. You can't be doing business with a city contractor. If you and this is something that could happen almost unless you're completely aware of every contractor. I could imagine some employee might get into this without realizing it, but certainly elected officials would know who the city contractors are. You shouldn't be getting involved in doing business transactions or contracts with a company that does business with the city. All right, that's a problem under your code. Yes. Do you want to don't say anything if you need a lawyer first now.
Actually, I don't know all the cities. It's not like I'm doing business with anyone right now, but I don't know all the cities contractors. So
good idea to find out. You're an elected. Well, I would think you would, but you certainly have access to the information. I think you should make it your business to find out who your city contractors are.
You need to give us a list of all the city contractors.
I think, I got an opinion from the previous city attorney. I'm going to ask that opinion again, but, if you can comment on that one. Prior to being the mayor for the city of North Miami, I used to represent people that were wrongly accused of crimes by the city police department.
You only represented innocent people?
Only innocent people. And I used to make maybe $70,000 a year just representing folks that were wrongly accused by the city of North Miami. The previous city attorney said I cannot do it anymore. I didn't get that opinion in writing. I'm going to be requesting that opinion because that's killing my law practice.
Well, when you say people, to representing them in criminal court.
Criminal court, yes.
I think that's a problem. I would get an opinion from your city attorney, but that puts you at, if you're going to represent somebody who's being charged by your police department, that means you go to trial, you're going to have to cross-examine your police officers. What kind of a conflict? Don't you think that's a conflict? If you're to be cross-examining your own police? Do you not agree? I think that's a problem. But get an opinion. Maybe your attorney will disagree with me. Yes, sir.
One of the things that's been put on my desk is that we have an employee who, and I haven't found any type of council approval, but it's a contract where we have an employee who is running a tennis program. But they're paid by the city, but they're also are doing a tennis pro program as a contractor. So it's a city employee who also has.
Well, are they a private? But is this a full-time city, a regular city employee, not someone that contracts with the city?
Full-time regular city.
And they also have a contract with the city. I think that's a problem, but I would look into that.
Well, I've been waiting for the answer from your office.
Oh, okay. I mean, we look at all the factors, and there are times when, because there are the certain circumstances make it more of an arm's length thing. That was the right thing to do, was to ask for that opinion, because we'll provide that. Okay. Voting conflicts. If you're an elected, this really just applies to elected officials, mayor and council members. You may not vote on a matter coming before the council if you have a relationship with the individuals who are going to be affected by that vote in what fall into one of these categories. You're an officer of the corporation. You're a director of the corporation that's asking that you're voting on. All right. You're a partner of the person, a business partner of the person, or you're a consultant or an employee. I mean, your boss comes in and asks, your boss in the private sector, or just your law partner, let's say, if you have a law partner. You should be voting on something that affects your law partner or your business partner as a member of the city council or as a voting member of the board. Or if you have a debtor-creditor relationship, let's say, with somebody, you really shouldn't be voting on something that might affect that person differently than it's going to affect the general public. If you're voting on something that's going to affect the entire public, well, okay, then it's going to affect everybody equally. But if and this happened in another city some years ago, and I charged it as a criminal violation. Somebody had a loan that they had taken out from an individual. It was a large loan, and they didn't disclose it on their financial disclosure form. And then this guy that he owed the money to came and applied to the commission that he was a member of for, I think it was a zoning change, and he voted on it. All right, and he hadn't disclosed it that he owed this guy substantial amounts of money. That was serious enough, in my opinion, to justify a criminal conflict of interest charge, because it wasn't ordinarily that would be an ethics charge, but where he hadn't disclosed it and had kept it secret and then voted on it, I thought that made it a more serious matter. Okay, and if you're an elected official and you might yourself be enhanced and you might have one of these conflicts. What you need to do, if you have a conflict of interest, not only do you not vote, you don't discuss it. You leave the room. You're out of the discussion completely. That's really what the county code requires. Okay. There's a number of other prohibitions that you shouldn't have investments personally or through family members that will create a substantial conflict between your private interest and the public interest. Now, what does that mean? That's a very subjective thing. I mean, that's not something that's clearly understood. When does something amount to a substantial conflict? Well, let me tell you, these things can happen when people don't even realize it or aren't even thinking about it. A few years ago, there was a very well-publicized case. This involved the city of Miami. And these involve some smart people. The then mayor of the city, not the current mayor, the mayor of the city of Miami, the city manager of the city of Miami, and one of the city commissioners in the city of Miami formed a company, a real estate company, and said, and they thought this was okay because this had nothing to do with their public positions. They weren't using their city hall offices to do any business. No, this was something they were friends, and they said, look, we can do this on the side, nothing to do with our jobs. Why can't we do it? They formed a company that was going to, buy homes and rehab them and sell them and make a lot of money. So what do? They get a mortgage. So now they all owe jointly on this piece of property. They buy the property, they rehab it, and they sell it for a substantial profit. Okay. Then it comes out that okay, this is what happened, and it comes to the Ethics Commission. Well, they may have been thinking that this doesn't affect our jobs, but wait a minute. Who hires the city manager? The mayor and the commission. Who fires the city manager? Who sets the mayor's salary? The commission does. I mean, there are all these little ins and outs, and so what you got here is obviously, you're a member, and during this time, by the way, the commissioner voted to raise the mayor's salary $50,000. Well, that's his business partner. They're jointly in business together, and they both owe $400,000 to the bank, and he's giving his business partner a $50,000 raise. Do you see the problem here? I mean, this is clearly a situation where there's a conflict. How can he be objective in deciding whether his business partner deserves a $50,000 raise? He can't be. So that's a conflict, and these guys got in a very embarrassing conflict, and they didn't go to jail for it because it was an ethics problem, but very embarrassing for all of them involved, and Could have been avoided if they were just thinking at the beginning, wait a minute, before we start this, let's get an opinion, let's go to the Ethics Commission, let's ask them if we can do this. Would have told them, don't do it. But they didn't think to do it, and they all got black eyes as a result. You shouldn't participate in anything affecting indirectly or indirectly a business that either you or a member of your family has a financial interest in. Now, I mean, it doesn't mean that you're going to set a tax rate, let's say, in the city, or you're going to come up with a policy that affects everybody in the city, and it's going to affect you and all your relatives. We're not talking about that here. It's if you're voting on a specific matter that's going to impact that, that business or that family member, differently from the rest of the public. That's really what we're talking about. You shouldn't you acquire a financial interest in a matter in which you know that either you or a family member is going to be affected by your actions as a public official. You're not supposed to recommend services of professional firms, let's say lawyers or architects or public relations firms, unless it's something that's if it's part of your job to make a recommendation, that's one thing. But as a commissioner, let's say, or a council member, you're not supposed to be recommending to the city that they hire this particular architect or public relations firm. You have to vote on those matters maybe, but you're not permitted under the Code of Ethics to try to influence the process in terms of who does get hired, other than voting, which is your job. Yes?
If a contractor comes to you and asks you for a referral.
A referral? What do you mean by referral?
For example, let's say someone asks you if you know an accountant, okay, and that business is doing business in the city, can you give a referral?
You mean outside the city government? That's different. In other words, refer them to somebody outside. This has to do with recommending their services to the city. In other words, going to a city department head and saying you ought to, hire this firm. No, if you're talking about something outside the city, that's a different matter.
But you're saying that has nothing to do with you referring someone to go apply for a city job.
Oh, sure. If somebody wants to work for the city and they want to get a city contract, you can tell them, sure, go see so and so and fill out the forms. Yeah, that's not a. You're not then effectively trying to influence the process. Okay. There are some prohibited employments. Again, some of these things are. You can see how it's not that black and white. There are gray areas here. You cannot accept any employment outside of your city employment if you're an elected official or an employee or even a board member on one of your advisory boards if it would impair your independence of judgment in the performance of your public duties. All right, the guy in Miami violated this because he got involved in a business in which was clearly going to impair the independence of judgment that he was going to have, say, the commissioner in voting for a raise for the mayor. You need to disclose your employment, your outside employment, and under the North Miami Code, you need to basically, make sure that you get your approval in writing, and it's kind of common sense. Any employment you have outside the city should not use city time or city resources, should not be in any way adverse to the city. Mayor, your question regarding representing somebody against the city, I mean, effectively, that kind of employment is adverse to the city because the city has arrested somebody and charged them with a crime. I mean, I think that's a tough thing to say, it's not adverse somehow to the city. I'm not saying you shouldn't get an opinion, but I think it's a problem. You may not, as an elected official, appear before another city board and make a presentation on behalf of another party. In other words, lobby another board on behalf of somebody. It doesn't mean you can't appear before a board and speak your mind and give your opinion about something. I'm sure you do that from time to time, but you can't effectively represent somebody before a different city board. And even your board members, people who are on your different boards, they cannot appear before their own boards. Those people could appear before a different city board under some circumstances, but they should not ever appear before their own board. All right, that kind of is as far as I'm going to go with the ethics ordinance. I think everybody's been very patient for this 2-hour plus presentation. But before we go, I want to ask, does anybody has any other questions, any other issues that we may not have touched on that you think you would like to hear from? Yes, sir.
Yes, I have a question. Mr. Centerino, I'd just like you to expand upon a little bit something that I think I heard earlier on major agenda, or on agenda items that are introduced for a vote without any notice from the dais. For example, a meeting might be properly noticed, but you can have an item that isn't on the consent agenda. It can involve something as small as an athletic league contribution or as big as a $500 million development. And it comes from the agenda. I think I heard you say that it was undesirable but not prohibited under the Sunshine Law.
I'm not sure if I said that, but I think that is correct. That is correct. In other words, there is, and then this happens at public meetings. Somebody will make a motion suddenly that nobody knew was coming. As long as it's a properly advertised public meeting, that doesn't render that improper. Is it something? If it's something that's rather controversial, is it something that maybe you ought to have notice, and maybe you ought to give the public some notice before you do it, as a matter of sound policy and proper ethics and public procedures? I think it's always a good idea to give the public notice when it's something of some significance. Obviously, a lot of times things that are pretty minor will come up and really nobody's going to care. But matters of great public import that deserve public input, sure. I think that the better policy is always to get public input. Anything else? Any further? Okay. Well, I want to remind everybody that we're open for business, and we will, if you have a question, and I've told you a couple of examples of people that didn't ask a question and found to their chagrin that they were in some trouble. You could avoid that. And the county doesn't give you a lot of things for nothing, but they do give you the Ethics Commission, and they don't charge you for it. And take advantage of it. We'll give you an informal opinion. We'll give you a formal opinion. We'll guide you if you just want to have some off-the-record guidance. We'll do that. And it will save you a lot of trouble and a lot of aggravation if you take advantage of it. We're also open to the public generally. If the public has a question about something, we would talk to you, even though you cannot ask for a written opinion about somebody else's conduct. You're not able to do that. But we can certainly give you general guidance. People call us all the time and say, what about the Sunshine Law in this situation? Is that a problem? And we'll talk with you. We have a hotline. We've got a website. We've got information on there. All the opinions that we give out or show up at some point on our website. And we're expanding our operations. We're doing more and more training, more and more education and outreach. And even though we're a small agency, I'd like to think we're a mighty agency. And appreciate your having us here. We'll come back.
Thank you.
All right, guys.